start. What did you guys think of my new intro song? I really dig it. I think it's cool. I loved the other one too, but unfortunately, for whatever reason, license rights or something for being able to monetize your videos, I have no idea. I have like a Canva Premium, which is where I got that, and so I have a license for it, but I don't know how it works across whatever. And they just, they flagged it. I didn't want to deal with it. So I'm like, let's just change my theme song. So I hope you guys like that one. I think it's cool. Anyways, you guys don't care about the backstory. So I am here, or maybe you do. I don't know. It's kind of fun doing all this stuff in the behind scenes. But anyway, so we are here. I just wanted to show you the thumbnail real quick. So this is the contempt hearing. We're going to go through a couple of different court documents today. So we have over the weekend the state. So Nick McClelland responded to the contempt, or not. I'm sorry, not the contempt. The motion to compel and request for sanctions. So the defense previously requested sanctions and to compel discovery from Nick McClelland. We've gone over those in previous videos. And so this was the state's response. Unfortunately, it came in over the weekend, and I was just kind of feeling burnt out, and I didn't know how to explain everything and all the contempt stuff that was going on. Because I watch so much true crime stuff on YouTube. I love it. I consume it like 24/7, and it's just my life. I really enjoy it. And so sometimes I just get burnt out, and then I need like a couple days off. And so here I am back to it. And I'm so glad that these came out today. We have a couple of other filings that we're going to go through, which is the post-hearing memorandum. And then we have some issues ordered by Judge Gull. So let's get to it. We've got a lot to do, and I'm sorry about the way that this looks. I can't really make it any better. They just, they kind of look, they're like images, so they kind of look blurry when people upload them to Reddit, and this is the best that I've got at the moment. So I apologize, but we're going to get through. So I'm reading it, so hopefully it doesn't hurt your eyes and you don't have to strain. Just me. So the state's response to the defendant's amended motion to compel and request for sanctions comes now the state of Indiana by prosecuting attorney Nicholas C. McClelland and respectfully files its response to the defendant's amended motion to compel and request for sanctions filed March 17th. The state would ask the court to consider the following. Number one, in response to request paragraph 5A on January 30th, 2024, the O2D2, C3PO, I don't know, the O2D2, Allen Physical Discovery Release signed by Sarah Luxembourg, assistant to Brad Rosie, specifically notified the defense of videos that are missing corresponding audio. Specifically on page 5 in the 6th bullet point is stated the hard drive labeled Delphi DVR Drive 1 export containing uncatalogued interviews from Franklin Street Investigation Center. And that was from 225 to 407 in 2017. There is no detectable audio on the original drive from which the duplicate was made. This is the same loss described in the Delphi Police Chief Mullen 2-page letter describing loss of data from inserting drive 1 into DVR to extract an interview file, and a DVR malfunction reformatted the drive, thereby appearing to erase all files. That sounds suspicious to me. Do we have any experts, like technology experts? Is this even possible that this can happen out there? Let me know. He inserted a drive into the DVR to extract a file, and it malfunctioned and reformatted the drive. The whole drive. I don't know. Okay. So anyway, however, the belief at that time was that the lost files were interviews from 428 to 61, Chief Mullen was, at that time, making an educated guess as to the dates of lost files, when in fact Drive 1 was taken to Indiana State Police for recovering effort. That Drive 1 was in the possession of Indiana State Police from approximately June 2018 until approximate November 2022 for recovery efforts. And a copy of the original Drive 1 in its current state is described as O2D2 Allen Physical Discovery Release. And that makes me laugh. Okay. So therefore, it is now known that the video files on Delphi Drive 1 export are interviews from the dates of 2/25/17 through 4/7/2017 without audio, as audio files were not recovered while the video files were recovered. So you got the video, just not the audio. Sorry. How does that happen? Is this even possible, guys? Is this possible? I don't think so. All right, so number 2, in response to request paragraph 5B, the state provided 2 reports to Steve Mullen, created when he was Delphi Chief of Police, regarding the 2 instances of DVR malfunction resulting in lost interview recordings. These reports were including in response to defendant's March 8th, 2023 certified letter. So they're saying this happened on 2 incidents that they lost all the footage. In addition, Carroll County Prosecutor Investigator Steve Mullen testified at length during the hearing on March 18th, 2024, explained the efforts made to recover the data, circumstances surrounding the 2 DVR malfunctions, and was subject to cross-examination by the defense. I hate how he starts all of his sentences that. C. That in response to this pleading, Investigator Mullen searched for written communication with Indiana State Police regarding Drive 1 from the second incident of DVR malfunction and found an email from February 28, 2018. D. The specific to this motion to compel, Investigator Mullen would testify that the recovery software from China was not able to be produced through a local agency. Therefore, he contacted Indiana State Police Brian Bunner, and ISP did purchase the software. So Indiana State Police purchased the software, but it is not successful in recovery of Drive 1. No Indiana State Police report was generated because that was not a forensic examination. When the drive was returned, Mullen was gathering all investigation materials in his capacity as prosecutor investigator. As what? What was his? As what? Sorry. As prosecutor investigator. Mullins had a capacity as prosecutor investigator? Those are 2 different things. I'm confused by that. Anybody else catch that? He's a prosecutor and an investigator? All right, back to it. All right, so E, upon preparing the copies of hard drive data for discovery in this case, prosecutor investigator Mullen made a more thorough examination of Drive 1 and documented, as stated above, that hard drive labeled Delphi DVR Drive 1 export contains uncatalogued interviews from Franklin Street Investigation Center, 225 to 407 2017. There is no detectable audio on the original drive from which the duplicate was made. There are video files only. Okay, so multiple times he's telling us the same thing. Then in response to request paragraph 5C, if the defense opens the files containing law enforcement reports and runs a keyword search based on the date of the interview, the results should direct them to reports referencing the date for a determination of who participated in interviews on said date. So they don't even have, like, that's the thing that bothers all of us, is that the state just lost all of these interviews for months at a time, and we're just supposed to go, oh well, They didn't even like try to recreate these interviews or go back and find the people who they interviewed because I think they were destroyed on purpose, but that's speculation on my part. Anyways, the state has not compiled a list of who was interviewed or which officers conducted the interviews. Don't you think that's important, though? You lost all this footage. Don't you think you should make a record of what happened? All right, so during the date center in question, because without audio, the files are not helpful to the investigation or trial preparation of this case. I disagree. I mean, yeah, you don't have audio, but you should be able to go back and re-interview those people. It's not, I mean, it's not the same as the first interview, but you can still re-interview them and talk about what you talked about the last time. All right, so this loss is not the result of intentional conduct, but rather a malfunction of recording equipment intended to memorialize investigative reports. Yeah, blah, blah. We heard that story before. Number 4, in response to request to paragraph 6, the information has been provided in the discovery response dated March 8th, 2024, the testimony of Investigator Mullen at the hearing on March 18th, and the contents of this response. No further explanation has been reduced to writing. Okay. Number 5, the defense, paragraphs 7, 8, and 9 are statements rather than requests. Number 6, in response to request 10, phone dump data does exist and it has been provided. Number 7, in response to request 11, all geofence data to the state's possession has been provided to the defense and is listed in the discovery releases. The agency responsible for the interpretation of the geofence data is the FBI CAS team, specifically Special Agent Kevin Horan, who's retired now, and Special Agent Sabrick. Did they intentionally leave out their first name? Say, like, is this another special agent? Who is that? What's his first name? Number 8, that to the state's knowledge, the above response addresses all inquiries found within the defendant's amended motion to compel, wherefore the state of Indiana, by prosecuting attorney Nicholas C. McClelland, and whatever, I can't see what that says, something, their responses that like fell off the side of the page, the margin. Okay, yeah, so he is saying no sanctions. Ask the court to dismiss the motion for sanctions. All right, so here, now we're getting to the good stuff. So here's the post-hearing memorandum. This just came out today. So this other filing that we just read, the state's response, that came out over the weekend. Not sure why, but it was filed with a Saturday date at like 10:30 at night. So just saying, that was before the Monday hearing or whatever. Or no. Sorry, not before the Monday hearing. Monday happened, and then this came just this Saturday. Sorry. So this just came out this Saturday. The hearing already happened at that point. I'm getting myself confused. All right, so post-hearing memorandum. I wish I could make this bigger, but I can't. As previously argued by the defense, the entire process for pursuing indirect contempt was defective. Should the court reconsider that argument, the defense would offer some additional authority. Quote, acts of an indirect contempt, on the other hand, are those, quote, which undermine the activities of the court that fail to satisfy one of the direct contempt requirements, end quote. And that is from, he's quoting Hopping. Indirect contempt proceedings require appointment of a special judge and an array of due process protections, including notice and opportunity to be heard, which they were not given. So State's Exhibit 1 was the press release from the defense that the prosecution alleged constituted indirect contempt. Mr. Rosie testified as to 3 legitimate purposes of the release. Number 1, put an end to the incessant and inordinate requests from the media. 2, respond to the torrent of detailed information disseminated by state actors and family members. Usually, you want to respond if there's some misinformation there or something. So see the Defense Exhibit T, which identified over 130 press conferences, press releases, and media disseminations. And number 3, to generate tips to assist with the defense of Mr. Allen, of which there were many that were very useful. Interesting. So they got a bunch of tips. It bears repeating that the press release did not violate any existing court order. Mr. McClelland represented to the court that the gag order was issued December 1st, 2022. The court accepted his representation when taking judicial notice until the defense challenged it. Both then conceded it was issued December 2nd. So the press release went out the 1st, and then the gag order was instituted on the 2nd. So they did not violate anything. So they probably called for the gag orders, probably McClelland calling for a gag order because they didn't like that the defense was talking to the media. Anyways, it is understandable that Mr. McClelland and Judge Gull may have taken umbrage at the press release due to prior unrecorded conversations in chambers. Quote, however, the contempt power does not lie to soothe the wounded sensibilities of a judge. That's great. That was great. Okay, so basically, your feelings are hurt. Too bad, Judge Gull. You don't like the way that they're doing whatever. That's a big effing deal, you know? Do your job and stop with all this garbage. All right, so that was according to Accord, Maccabee versus State, and Grimm versus State. So to the extent the court believes there was a violation of rule of professional conduct, trial courts do not have jurisdiction to review such as noted in the first memorandum on contempt filed by the defense. They already told Judge Gull, you don't have any jurisdiction over my guys, my clients, the lawyers here, because this is coming from Hennessy, obviously. So he's saying you don't have any kind of claim, any kind of jurisdiction, any way to impugn these folks. I mean, you can always, a sanction could always be asked for or whatever, but that's not what they were asking. She wanted to remove them, so I think they just didn't like Baldwin and Rosie and their strategy to defend Richard Allen. To the extent that the court believes there was a violation of rule of professional conduct, trial courts don't have the jurisdiction. State's Exhibit 2 was the attachment to the accidentally misdirected email to Brandon Woodhouse. It was a thumb drive map. Mr. McClelland, so basically just a list of things. Mr. McClelland complained that it contained names. It did contain names, but that was necessary to be able to identify what was where on the thumb drive. It was nothing more than the Discovery organizational outline. So there was nothing in that outline that identified any substance of interviews or conversations with the persons named or any other substance at all. So it was just a list of items that they needed to use in discovery. Compared to the leaks of 2 entire probable cause affidavits, which contained details of the investigation, the disclosure of the discovery of a bullet and a gun, and others, the thumb drive map was insignificant. Mr. McClelland argued that was a violation of a protective order. First, it was not disseminated. The definition of disseminate is to spread widely. That email was sent to one single person who was an unintended recipient. The evidence showed that Mr. Baldwin contacted Woodhouse within an hour to have him delete it. Second, Mr. Rosie testified concerning an in-chambers conversation where the protective order was intended to prohibit public disclosure through media outlets. His testimony was not contradicted. State's Exhibit 3 was a discovery receipt that was not admitted. State's Exhibit 4 was the email string between Messrs. McLeland, Baldwin, Rosie, and Judge Gull concerning the leaks and ensuing investigation. Mr. Baldwin and Mr. Rosie cooperated fully and without delay. They were open, honest, and complete in their communications to the investigators and the court. So, just a little side note here. McLeland, or sorry, not McLeland, Rosie, Baldwin and Rosie have like just phenomenal records as attorneys, as defense attorneys. They are highly sought out, they are very good at what they do, and they fully, engage in their strategy, and just like, they're doing with Richard Allen, and how they believe he's innocent and they are fighting for their client. And so for them to be characterized as, um, performing, misconduct and contempt and whatnot, it's a huge slap in the face, and it's appalling that I really feel like McLeland and Gull are a team, like working together to get rid of them. It almost seems. It almost seems like they are, thinking, just their thoughts are just right in alignment with one another. And she never wants to hear from the defense. But anyways, I can go on about that. So they were open, honest, and complete in their communications to the court. State's Exhibit 5 consisted of 5 pictures which the state alleged were disseminated by Fortson. So this is the leak, okay? And I'm calling it a leak with my air quotes because it was barely a leak. It was potentially a drip. So it didn't get out to, like, as he just explained, disseminated means it needs to get out to a wide amount of people. These pictures never got out. They were stopped. Luckily, they were stopped before they ever did get out to the public. So thank the brave souls that did that. But I don't know. Supposedly Murder Sheets or Murder Sheets podcast, something or other, they had something to do with it. I don't know the whole details. I don't like to get into the drama. I just want to get to the facts. But they are part of the story now because the emails were sent to them. So anyways, here, let's read what happened. So State's Exhibit 5 consisted of 5 pictures which the state alleged were disseminated by Fortson after he received them from Westerman. So Westerman's the one that took them, and he gives them to Fortson. Fortson has now self-deleted, and we're not sure why. Or did he? I don't know. But that's the story now. So Sergeant Holman testified that he believed he had seen them at a deposition. Mr. Rosie testified that he reviewed the deposition exhibits and compared them to the 5 photographs rather than rely on memory alone. He then testified without contradiction that 2 of the photos were not created or used by the defense. Thus, those 2 could not have come from Westerman. So 2 of the photos were not coming from the defense, at least. So where did they come from? Potentially the prosecution? Think the prosecution maybe put Westerman up to this? I don't know. To the extent they may have come from Fortson, he had many other sources as confirmed by State's Exhibit 6, which was 143 pages of Fortson's communications. So Fortson had other sources. Westerman might have even had other sources. We don't know his full extent in it either. So the remaining 3 photographs were not offensive and would eventually be made public. Interesting. So the 3 photographs that could have potentially come from the defense's office would have been made public anyways, and they weren't of anything that people would find offensive or, not want to see or blur out or whatever. So it was not dissemination of damaging information. The evidence disclosed many sources of the photographs that were never investigated. So you can't for sure say that these leaked photographs all came from the defense, because there's doubt there that, some of them came from somewhere else. The most egregious leak was the detailed probable cause affidavit to search Logan's property. Sergeant Holman testified he asked Barbara where she got and she said from Logan. Where she got something. I don't know. However, he also testified the search warrant affidavit is never left with the person, just a copy of the search warrant. Thus, Barbara's statement had to be false. That affidavit also had, quote, what does it say? Murder sheet overlaid on every page. Sergeant Holman never asked the murder sheet people about it and never did any further investigation as to the source. So the people for Murder Sheet got these leaked photos, but we don't know that they came from Westerman or Fortson or where they came from, because Sergeant Holman didn't do his job and actually investigate where they came from. We can't prove anywhere because you didn't investigate. You can't prove that it came from my client. State's Exhibit 6 was 143 pages of Fortson's communications. The state had previously provided undersigned counsel 145 pages. At no time did they disclose what pages were removed or why. Not once did Fortson identify Westerman as his source. Not once did he describe any direct contact with Andrew Baldwin. Not in person, not by phone, or any messaging application. Awesome. So there's no connection to him and Fortson, who is the one who leaked the photos to Murder Sheet or wherever, maybe. I don't know. The state argued that Fortson saying he was going to Franklin somehow connected Fortson to Baldwin because his office was in Franklin. That is an unsupported leap in logic. There was no evidence that Fortson actually went to Franklin, and there was no mention of Andrew Baldwin regarding his trip to Franklin. The state ignored Westerman's ties to Franklin. So, I don't know who Franklin is. Who is Franklin? He was going to Franklin somehow connected Fortson. Is Franklin a place? I'm not sure what that means. Throughout the 143 pages admitted, there were only 4 references to Andy. The first was that they may have Messer's phones. She tried to give it to Holman, but he ghosted her, so she gave it to Andy, is the quote. No source was identified for that information, and it was not attributed to, quote, Andy. The second was that Andy had audio of Professor Turco's statement. Professor Turco, the one that said that it had Odinistic runes or whatever, Odinist ties, the crime scene. So this Andy person had a audio recording of Turco's statement. The third was that the judge was setting a suppression hearing, but Andy is seeking clarity. Those 3 references did not identify the source of the information and was not attributed to, quote, Andy. The last was that he's going to be with Andy tonight. There is no indication who he is or what they might be meeting about. There was no evidence of any meeting. Again, he did not identify any source for his alleged information. State's Exhibit 7 was Andrew Baldwin's email to Judge Gull copying all the other attorneys. He began by saying, "We want the leaker caught." He related what he knew as of October 9th, 2003, regarding the photographs and other leaks. He ended with the suggestion that the FBI should investigate if he had knowingly, intentionally, or willfully participated in any dissemination of any photographs. He would never have suggested the FBI investigate because, duh, you're like telling on yourself. So, State's Exhibit 8 is Mr. Rosie's letter to Judge Gull, consisting of 7 pages. He disclosed all that he knew about the, quote, leak, and reported other more sensitive and damaging leaks for the court's consideration, leaks done by the prosecution that were very damaging to the case. All right, so State's Exhibit 9 is Mr. Westerman's affidavit, which clearly establishes that what he did was not known to Mr. Baldwin and that Mr. Baldwin did not participate. Again, the contempt had to be willing. In order to be found in contempt, they had to be found willing and knowing of this leak. But Westerman took them without Baldwin's knowledge, and he stated as such in an affidavit. He admitted that what he did was without any authorization whatsoever. State's Exhibit 10 consists of 20 pages of back and forth messages between Mr. Baldwin and an unidentified person. The state alleged that person was Mr. Westerman. The exhibit was admitted over objection because it contained Mr. Baldwin's mental impressions and work product and failed to identify the other participant. Mr. McLeland read the exchange with advanced knowledge that it was communications regarding consultation on the case. He never should have read it. He read a bunch of ex parte motions as well. Oops, I wasn't done with that page. So Mr. Rosie testified about an in-chambers meeting with Judge Gull, Brad Rosie, Andrew Baldwin, Nick McLeland, and perhaps one other prosecutor involved in the case early on. Mr. Rosie testified that during that meeting, Judge Gull clarified that the parties could share information and brainstorm with anyone, that the intention of the gag order was only to prevent the parties from holding press conferences, sending out future press releases, and conducting interviews with media, which is stupid that you even have a gag order. These gag orders are dumb. These are all supposed to be in the light. Our judicial system is supposed to be in the light, and it's not. If people only knew how much is still done in the darkness. It's ridiculous. Follow the Karen Reed case. If anybody's not at this point paying attention to that, it's insane. The power that people have and how they abuse it, it's just beyond me. So Mr. Rosie testified in chambers, whatever, with all those people. And perhaps one other prosecutor. Mr. Rosie testified that during that meeting, Judge Gull clarified that parties could disseminate any information, brainstorm, The intention of the gag order was not to prevent you from press conferences, which in any other ordinary case, you'd be able to just call a press conference at any point and talk to the media if you needed help, or you wanted some clues from or tips from the public. You wanted to look at Idaho 4. They had a press conference anytime they wanted to get more tips from the public. They would share information about his car or about any little detail so that they could get more tips. And they were saying they were searching for this particular kind. So the state can do it. The state usually is the one doing it in most cases, and the defense has to stay quiet until trial, oftentimes, if they want to maintain their right to remain silent. Because if you start talking, anything you say in interviews in the media could be used against you. So it's just, it is what it is. I don't know. All right, so the intention of the gag order, blah, blah, blah. You can't do press conferences now. So that testimony was uncontracted. The defense tried to call Mr. McLeland as a witness, but the court would not allow it for some stupid reason. He had the opportunity to cross-examine Mr. Rosie regarding, so McLeland had an opportunity to cross-examine Brad Rosie regarding that conversation, but did not. The court cannot rely upon its own memory without being a witness, which would relate back to the defense's request for recusal. We want you gone, Judge Gull. You suck and you're biased. All right, so Mr. Baldwin's communications with Westerman and sharing of his Frank's memorandum with him and others for critique is exactly what was contemplated. The prosecution's allegation that Mr. Baldwin's discussions with Westerman violated the gag order is unfounded and not supported by the evidence. You're allowed to have consultants. You're allowed to discuss your case. If you're a lawyer, you're allowed to discuss your case, your strategy. You're allowed to like throw ideas out to get feedback. It's not like you have to keep your mouth shut and not ever speak about the case. You need help. You can't just do it alone. You need experts. You need people that you can talk to, that can consult with. So, yeah. Where did I leave off? I don't know. Allegedly, Sergeant Holman and Mr. Mullins testified that they were aware that Mr. McClelland was exchanging information with Gary Baudet. This is the YouTuber FigSolve, I don't know. The most prodigious leaker of all, okay? So the court would not allow evidence of the substance of those communications for some reason, even though it appears that there was somebody leaking stuff to him because he knew things before things happened in this case and said he was getting it from someone in the court. So it therefore is not known what information Mr. McClelland disclosed. Mr. McClelland and Gary Baudet. So he's the one that was talking to him. It would have been relevant and probative as to whether Mr. Baldwin's discussions with Mr. Westerman were prohibited by any rule or order or were inappropriate in any manner. If Mr. Baldwin is to be held in contempt, Mr. McClelland should face scrutiny as well. Yes, he should. Attorneys with combined criminal defense experience of 120 years testified that they would routinely consult with both lawyers and non-lawyers about the evidence in a case during trial preparation. They all said it was crucial to trial preparation and explained why. Those lawyers testified as to sending and receiving misdirected emails. They obviously had attorneys who had been, trial attorneys for many, many years, very experienced. So they were brought to testify as to their experience of being a lawyer and these little intricacies that happen when you're preparing a case. So these lawyers testified as to sending and receiving misdirected emails. They would address those mistakes exactly how Mr. Baldwin did. They also testified, contrary to Mr. McClelland's argument that Mr. Baldwin should have reported to him and the court, that it would not cross their minds to report such events to a prosecutor or judge. Notably, there was no evidence of any obligation for Mr. Baldwin to report to the prosecution or judge. Furthermore, he had immediate corrective action and reasonably believed it had been resolved. Yeah, like it's done. It's over with. Problem solved. I'm not thinking about it anymore. Why would I even bring it up again? Like, over and done with. I have other problems to deal with today. So each of those lawyers testified. That'd be my line of thinking. Like, okay, I told him to delete it. He said he would. Done. Like, moving on to problems 12, 13, 17, 29, all the other problems that are on my list for the day. So each of those lawyers testified it was standard practice for criminal defense attorneys and their regular practice to establish a separate area in those offices to spread out the discovery and anticipated evidence for trial preparation. Some call it like a war room. Like you have a room set up because you're not going to be pulling out evidence every time you're working on something. You might have one of those boards like the cops, the thumbtack boards where you have the string and everything because you're trying to put together your case and your strategy and you're putting the evidence together yourself and looking at it. So they never, where was I? Each of those lawyers testified it was standard practice for criminal defense attorneys and their regular practice to establish a separate area in their offices to spread out the discovery and anticipated evidence for trial preparation. They had never thought to secure the area because they never expected a betrayal like Mr. Baldwin suffered. No one expects to be betrayed. That's a great point. All right, so 8 additional experienced criminal defense attorneys echoed the testifying lawyers with affidavits that were not admitted. So you didn't let us admit a bunch more affidavits because you're a jerk, Judge Gull. The court declined to hear testimony and admit documents of much more detailed, serious and damaging leaks. It had been preserved in the record. Those leaks were purposeful and willful. The defense renews its plea for the court to consider such evidence when contemplating whether Mr. Rosie or Mr. Baldwin knowingly, intelligently, or willfully committed indirect contempt beyond a reasonable doubt. The Indiana Supreme Court in State versus Schumacher says that the appropriate standard in an indirect contempt proceeding is beyond a reasonable doubt. The court applied the beyond a reasonable doubt standards. And okay, so that was it. Oh, yeah, he signed here. So the court in this whatever proceeding applied the beyond a reasonable doubt. So you must convict my client of contempt only if there's beyond a reasonable doubt, but there is much doubt here. So anyways, that is from Hennessy. He also provided this is the appendix. So these are all the these are just I don't know. What is appendix 1? It's an outline, obviously, of something. I'm not sure what this could be. Potentially the thing that they sent to what's his name? Brandon. Not Brad, but Brandon. I'm not sure what this list is. I know. Okay. Yeah, I don't know what all these are. I mean, out of context, I can't really tell what anything means. Told no rocks about everything. Elvis Fields duped by Mike Thomas. So this might be something. Message from Holman where he contacts Woodhouse. Got more coming. I don't know what this is, but it's almost like banned me in. I wonder if there's information down here. These are oh, gotcha. These are messages between Fortin and Westerman, right? I agree with Nick. Okay, so somebody said that. DH is absolutely trolling. I don't know what that means. All right, so these might be the messages between. Whoops. But like they don't make sense. They don't look like messages. So I'm really not sure. Hopefully there's some clarity in the future about these. Yeah, I don't know what those are. Kelsey, Chase, and Bry lawyer up. Jones Air Force left town. Who left town? I don't know. Anyways, moving on. So these are the orders that Judge Gull had issued just today. So a few hours ago today. All right, so this there's a bunch of different ones, so let's go through them. So this is one for whatever this is. Defendant appears in person and with counsel, attorneys Bradley Rosie and Andrew Baldwin. State appears by prosecuting attorney Nicholas McLeland, deputy prosecuting attorney James Luttrell, and deputy prosecuting attorney Stacy Diener. So she's a new one that just got added to the prosecution's team. And it's interesting her name's Diener when we know that there was a Judge Diener in this that recused himself, and now we have the wonderful Judge Gull. So, I don't know. But there is a Stacy Diener. No idea if they're related, but it would be interesting to find out. All right, so the hearing held on defense motion to dismiss for destroying exculpatory evidence. Matter taken under advisement to review the evidence submitted. So Judge Gull had the, she went through the proper procedure, which was to have a motion, to have a hearing regarding the defense's motion for destroying all that, all the interviews between Brad Holder, Elvis Fields, and all of those. So her response is, we had a hearing. I'm taking it under advisement. Thanks. Moving on. This is probably going to be all of hers. All right, so this next one, defendant appears in person and with counsel, attorneys Bradley Rosie and Andrew Baldwin. Rosie and Baldwin appear with attorney David Hennessy. State appears by prosecuting Nick McLeland, James Luttrell, and Stacy Diener. Prior to the commencement of the hearing of the state's verified information of contempt conduct, the following preliminary matters are addressed. Number 1, the state's motion for leave to amend charging information by adding courts 3 and 4 is granted without objection. Of course, it's the state's motion, so of course it's granted. Counsel waive initial hearing on counts 3 and 4. I don't know what that means. Number 2, the state's oral motion to dismiss counts 5 and 6. That's why. They amended the charges for Richard Allen. So that's what she's talking about. He was only charged originally for kidnapping, and now it's for the unaliving. I don't know why it was the lighter charges, but now they have them on the homicide charges. So I don't know. I don't know what games they're playing here, but it's fun for them, I guess. Messing with people's lives. The state's oral motion to dismiss counts 5 and 6, kidnapping, level 3 felony, granted without objection. So they dismissed those, and now they're adding the homicide. The verified petition for recusal of prosecutor for contempt proceedings is heard and denied. So, nope, I'm not taking Nick McLeland off there. I don't think he is biased, and I don't need to hear you on it either. State withdraws its motion for all future pleadings and filings to be sealed for the court's review before being released to the public. Attorney Hennessy's verified emergency motion for continuance and supplement to verified motion continuance denied. So he wanted a continuance of that hearing. Multiple times he put in motions for such, and all denied. Attorney Hennessy motion for stay all ancillary proceedings and get this case to trial, and the state's objection heard. As the hearing is proceeding, the motion to stay is denied. So because we're doing it right now, I denied. What? All right. So court has previously granted attorney Rosie and Baldwin motion for a speedy trial, and the cause is now set for a speedy trial May 13th through the 31st. Attorney Hennessy's motion for specific findings of fact and conclusions thereon granted with respect to the contempt hearing. She granted them something? What? Attorney Hennessy's verified petition for recusal from contempt heard and denied. Attorney Hennessy's objection of change of venue noted. No objection has been made by the defense counsel or defense counsel's attorney until March 12th. The hearing was previously set in February and continued to March 18th on defense counsel's motion without objection to the hearing taking place in Allen County. Court overrules the objection, but will conduct future hearings, if any, in the Carroll Circuit Court. What is her deal, man? Like, that makes no sense. We're just going to do it here in Allen County, even though it's all been in Carroll County this whole time. But let's do it in Allen County today. And then we'll go back to Carroll County. She's losing her mind, I think. Court then conducts the hearing on the state's verified information of contemptuous conduct and takes the evidence and arguments of counsel under advisement. Meaning, I'm not, that's like when you're a kid and you're asking your kid, like, hey, Mom, can I go spend the night over at blah blah's house? And she's like, well, I'll think about it. And you know that means no. That's what Judge Gull's, I'm going to take it under advisement. That's what that means. Court then conducts the hearing on the state's verified information of contemptuous conduct and takes the evidence and arguments of counsel under advisement. Attorney Hennessy requests an opportunity to submit a post-hearing brief. So that was probably his memorandum. Court orders him to submit same on or before the 25th. So that's why he had to get it out today. State will submit a response brief on or before April 1st. So April 1st or before that, we should be hearing from the state regarding this Hennessy document that we were reading here, regarding all the things that Judge Gull and the state did wrong during their contempt hearing that we just read. So those are the motions that we have right now. There is another motion that I think I missed at some point, and it was something, I mean, there's been so many motions, it's so hard to keep up, but at some point, the defense asked for more money for their experts, or for money for their experts, and Judge Gull denied it. So basically, Richard Allen has no money, and if he needs to hire experts, it's going to have to come out of Rosie and Baldwin's pockets, and hope and pray that they could maybe get some kind of reimbursement or something later, but I doubt it. I mean, I don't know. I don't know why she's not giving them a level playing field. The state has all the power, all of it. The state can control what the law enforcement is doing. Law enforcement can dictate what information is given to the state versus exculpatory evidence that doesn't come in. So there's a whole lot of trust in our judicial system that everyone's doing everything right. But there's so many areas where someone could be doing something wrong and it ends up being an injustice for someone. Potentially this case. Just saying. It is an injustice that the families of Abby and Libby are still waiting for a trial. And they've had to sit through all this garbage with the attorneys because Judge Gull kicked them off and delayed it many more months. So it's a shame. And it's also a shame that I think she denied cameras for, that might have been another motion. She denied cameras for the trial itself, which would be, that's a travesty. That's awful. Like this case in particular, so many eyes are watching. We need to shine light. Sunlight is the biggest disinfectant. I love that line because in order for us to get to the bottom of this stuff, we need everyone's eyes on it. You know, I mean, you can't just keep these secrets buried any longer in these small towns. I started this channel because of this, because of corrupt BS like this. And this is what I want to report on because I think it's so wrong. It's not what our justice system was meant for. It's not what our forefathers of this country would have wanted it to be. I am seeing our statutes and rules being weaponized against people, like Turtle Boy being thrown in prison for 60 days. just because they didn't like that he was reporting on the police that are the corrupt ones. So it is, I just can't believe my eyes and what the world is, what's going on in the world right now. And the thing is, this has been going on for centuries. That we're just now learning about it because of the internet, because we can, because we're connected to other areas of the world now because of the internet. We didn't know this was happening before, not on the grand scale that it's happening now. So it's a scary thought, and any one of us could be railroaded by law enforcement, by a prosecutor. Any one of us could be Richard Allen or Karen Reed, Turtle Boy. Any one of us could be in a bad situation like that and be innocent and be fighting for your life. So it's depressing. Maybe that's why I needed a break from doing my streams. But anyways, I didn't mean to take it in such a dark turn. I really do, like I said, we need to shine a light on this, and that is the only way that it's going to stop. So I'll leave it on that note. Hopefully, by people like me, people like you guys watching this, just learning about it and being outraged about it as a human being, as a citizen of this country. You should be outraged by what's going on with Richard Allen. If you're not paying attention, that's why you're not outraged, because you don't know what's going on. It should be just slapping you in the face how wrong things are over there. And I don't like it. I bet you guys don't like it either. So by continuing to watch, support, like my videos, continue to keep Richard Allen in the forefront, then we're fighting the system. So hopefully we've done a little bit of our part today. And on that note, that's our positive note that we will leave it on. So we've done a little bit of our part today to help Richard Allen and get some justice for Libby and Abby. So thank you so much for watching. Please, please be sure to like, comment, subscribe, and I will see you in the next one. Thank you so much. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.